Здравствуйте! Мы с вами продолжаем изучать тему Continental Law Systems. Напоминаю, что революции, прокатившиеся европейским и американским континентами, коренным образом изменили систему права и понятия о нем. Феодальные правовые институты были отменены, и закон превратился в основной источник права. Во многих странах Европы были проведены кодификации законодательства. Особо следует выделить две важнейшие гражданско-правовые кодификации того времени. Во Франции кодекс Наполеона и в Германии германское гражданское уложение. Ведь именно эти кодификации и повлияли на дальнейшее развитие системы континентального права. Второй курс, третье занятие, третий фрагмент. Тема Continental Law Systems. Exercise 1. Read and translate the text. Continental law systems. Continental systems are sometimes known as codified legal systems.
Континентальные системы права иногда называют кодифицированными правовыми системами.
They have resulted from attempts by governments to produce a set of codes to govern every legal aspect of citizens' life.
Они явились результатом попыток правительств создать свод законов, чтобы регулировать все правовые аспекты жизни граждан.
Thus, it was necessary for legislators to speculate comprehensively about human behavior rather than simply look at previous cases.
Таким образом, законодателям нужно было скорее всесторонне обдумать поведение человека, чем просто изучить ранее рассмотренные судебные дела.
In codifying their legal systems, many countries looked at the examples of revolutionary and Napoleonic France, whose legislators wanted to break with previous case law, which had often produced corrupt and biased judgments, and to apply new egalitarian social theories to the law.
В процессе кодификации своих правовых систем многие страны ориентировались на примеры революционной Франции времен Наполеона, чьи законодатели желали покончить с прежним прецедентным правом, которое часто порождало коррупционное и пристрастное решение суда, и применять новые эгалитарные общественные теории в праве.
19th century Europe also saw the decline of several multi-ethnic empires and the rise of nationalism.
Европа XIX столетия также пережила упадок нескольких многонациональных империй и подъем национализма.
The lawmakers of new nations sometimes wanted to show that the legal rights of their citizens originated in the state, not in local customs, and thus it was the state that was to make law, not the courts.
Законодатели новых государств в ряде случаев хотели продемонстрировать, что юридические права и граждан возникли в государстве, а не в местных обычаях. И, следовательно, именно государство должно было создавать законы, а не суды.
In order to separate the roles of the legislature and judiciary, it was necessary to make laws that were clear and comprehensive.
Для того, чтобы разделить роли законодательной власти и судебной власти, было необходимо создать законы, которые были бы понятными и всеобъемлющими.
The lawmakers were often influenced by the models of the canon law of the Roman Catholic Church, but the most important models were the codes produced in the 7th century under the direction of the Roman Emperor Justinian.
Законодатели часто находились под влиянием моделей канонического права Римской католической церкви. Но самыми важными моделями были кодексы, созданные в VII столетии при правлении римского императора Юстиниана.
His aim had been to eliminate the confusion of the centuries of inconsistent lawmaking by formulating a comprehensive system that would entirely replace existing law.
Его целью было устранить путаницу в противоречивых законах, которые издавались столетиями, создав комплексную систему, которая полностью заменила бы существующее право.
Versions of Roman law had long influenced many parts of Europe, including the case law traditions of Scotland, but had little impact on English law.
Римское право в течение долгого времени влияло на большую часть Европы, включая традиции прецедентного права Шотландии, но не оказало особого влияния на английское право.
Было не очень сложно, правда? А сейчас мы предлагаем вам послушать небольшие диалоги, которые помогут вам закрепить выученную лексику. Let's practice. Exercise 2. Listen to the dialogues.
Do codified systems significantly differ from codified legal systems?
No, they don't. Continental systems are sometimes known as codified legal systems.
Was France a case law country before French Revolution?
Yes, it was. The legislators of revolutionary and Napoleonic France wanted to break with previous case law, which had often produced corrupt and biased judgments.
Did lawmakers of new nations want to emphasize the importance of the state in lawmaking?
Yes, they did. The lawmakers of new nations sometimes wanted to show that the legal rights of their citizens originated in the state, not in local customs, and thus it was the state that was to make law, not the courts.
The experience of Roman Catholic Church was of little importance to legislators of the 19th century Europe, wasn't it?
No, it wasn't. The lawmakers were often influenced by the models of the canon law of the Roman Catholic Church.
Were there any other important sources of law besides Justinian Code for continental law creation?
The lawmakers in Europe were often influenced by the models of the canon law of the Roman Catholic Church, but the most important models were the codes produced in the 7th century under the direction of the Roman Emperor Justinian.
And how deep was Roman law influence on the development of legal systems on the British Isles?
Versions of Roman law had long influenced many parts of Europe, including the case law traditions of Scotland, but had little impact on English law. Вы хорошо потрудились, а теперь можно и отдохнуть. Предлагаем вам посмотреть интересный видеофрагмент о значимости закона и права в современном мире и о поворотных моментах в развитии законотворчества. Всего доброго. See you next time.
Imagine what it would be like if we didn't have any laws, if people did just as they pleased without any regard for others. Life would probably get pretty chaotic.
The defendant in this case has been indicted by the
Law
grand
is
jury
one of
this
society's
county
most basic
for the offenses of
institutions,
malice
and one of the most necessary. It establishes a person's rights and obligations. The law also sets penalties for those who violate these rules. Equal justice under law, reads this inscription on the Supreme Court of the United States. Although specific laws change over time, most people agree justice is one of law's guiding principles. One of the earliest known attempts to institutionalize law occurred in ancient Mesopotamia, a region between the Tigris and Euphrates rivers. It's where Iraq is today. This ancient king, Hammurabi, ruled over Babylon from 1792 to 1750 BC. At the beginning of his reign, Mesopotamia was divided into many city-states, all with their own pattern of shifting rules. But Hammurabi eventually brought the entire region under his control. He collected laws from the various city-states and wrote down a set of codes that soon governed the entire area. Hammurabi's written code allowed law to be a matter of public knowledge and so helped advance the rule of law in society. His code dealt with issues of taxes and trade, marriage and divorce, and theft and murder. He assigned specific punishments to fit specific crimes. The Old Testament reflects Hammurabi's approach, an eye for an eye and a tooth for a tooth. Hammurabi's empire eventually fell apart, but he's credited with establishing justice in the land. and the idea of codified law was just beginning. The codification movement reached its peak under the French ruler Napoleon Bonaparte. After he crowned himself emperor in 1804, Napoleon wanted to bring a new order to France. He restructured France's legal system into a new unified collection of laws known as the Napoleonic Code. A great military leader, Napoleon soon conquered most of Europe. Just as Hammurabi unified laws across Mesopotamia, Napoleon's ideas and reforms spread across Europe. He established new constitutions in the countries he conquered, and so the Napoleonic Code helped modernize an entire continent. And today, a small town in Texas attempts to bring justice to its community. They discovered here that the majority of crimes were committed by juveniles. So for first-time offenders of misdemeanors, a teen court was put into action. Here, teenagers are prosecuting, defending, and sitting on the jury. Punishment takes the form of community service. An important message is sent.
The first message is that laws are important and that they should be upheld, that young people have a role in both being law-abiding and seeing that the values of the community are enforced.
As civilization evolves, it leaves behind specific rules and laws established by past leaders and governments. What survives is the quest for law, order, and justice.